Hello, everybody. Welcome to another episode about the Code of Conduct. Today I'm here with Simon from Frichot Lawyers. Simon, welcome.
Thank you, Rita.
My pleasure.
Happy to be here.
Yes, there are a lot of people out there that have a lot of questions of where they stand and what's going on at the moment. And that's why I thought it was good to have other professionals sharing their view on things. So to start off, what is the purpose of the code?
So the purpose of the code really is to put in place a set of principles that will govern negotiations for temporary variations to commercial leases in circumstances where, due to the Covid-19 pandemic, the tenant is facing financial hardship. So clearly one of the key objectives of the code is to mitigate the impact of the pandemic on affected tenants, and it aims to do so in a proportionate manner. That is, the bigger the financial hit the tenant is suffering, the more substantive the relief they should receive. And the main way in which it seeks to do this is by providing that tenants should receive rent reductions in the form of waivers and deferrals in proportion with their drop in revenue. At the same time, the code also states that it seeks to balance the interests of landlords and tenants in relation to financial risk and cash flow issues consequent on Covid-19. Whether it does so, and in particular whether it goes far enough in protecting landlords' interests, is up for debate. So ultimately, the code seeks to establish a framework, a set of principles to guide landlords and tenants to negotiate reasonable temporary variations to their leases to get through the Covid-19 period, with the aim of normal trading and tenancy arrangements resuming on the other side. A couple of key things the code makes clear are, firstly, that it relies heavily on both landlords and tenants acting in good faith in relation to negotiations regarding these temporary variations of lease. And secondly, that as each lease is different, variations will need to be agreed on a case-by-case basis, having regard to these overarching principles.
I understand it. So there's a lot of negotiation going around. It describes the parties to the code, but in plain English, what does it mean? So the code says the code will be given effect through relevant state and territory legislation and regulations as appropriate. The code is not intended to supersede such legislation, but aims to complement it during the COVID-19 crisis period. So what does that really mean?
Yeah, it's a good question, and it's not that statement is not as clear as it could be. But what people need to keep in mind is that the code is a document that has been released by the National Cabinet. So it's not a piece of legislation that binds people in the way that legislation does. Okay. And as you mentioned there, the code contemplates that it's going to be enacted into law by various state and territory governments. And in Western Australia, this process is well underway. As in recent days, a piece of legislation called the Commercial Tenancies COVID-19 Response Bill has been passed by the WA Parliament, and when I last checked, was awaiting royal assent from the Governor. If this bill is yet to receive royal assent, then we anticipate it will receive that very soon, in the next day or so. Importantly, this WA bill will apply to what are defined in the legislation as small commercial leases, which includes retail shop leases, leases where the tenant owns or operates a small business and uses the leased premises for the purposes of running that business, and also leases held by tenants who are unincorporated associations. So once assented to, this legislation will do a few important things. First, it specifically legislates a number of the matters set out in the code, including the prohibitions on landlords terminating leases, increasing rent, or drawing on tenant security for non-payment of rent during the pandemic period. Notably, it does not legislate the provisions of the code regarding rent reductions, However, we expect that this will be introduced separately. Second, this legislation also sets up a mechanism whereby the rest of the code can be introduced into WA law through regulations. Importantly, these regulations can adopt only part of the code and can do so with or without changes. And indeed, information on the state government's website indicates that it will be making appropriate modifications to this national code that we're talking about when adopting it into state law. And we anticipate that the parts of the code that deal with these rent waivers and deferrals may be adopted in this manner, i.e. through the regulations. However, these regulations are not yet released at this time, and there's been some indication that they may be around a month away. Given that, we don't actually know exactly how the code is going to apply in WA until we see these regulations. But the really important thing for landlords and tenants to note is that it is this state legislation, the Act and the regulations, that ultimately will be what is legally binding in WA. So this, more than the national code itself, is what everyone needs to get their heads around: lawyers, managing agents, leasing parties.
Yeah.
And just another thing as well, just quickly, is that there's also been another separate bill recently introduced into WA Parliament called the Commercial Tenancies Covid-19 Response Early Termination Bill. And this bill provides for tenants of certain commercial leases who are suffering severe financial hardship to terminate their leases early in certain circumstances. But this bill has not at this time been passed, and there's been some indication from the government that it's only going to progress this bill if there's a widespread lack of cooperation and goodwill from landlords in relation to implementing the principles of the code.
Okay, all right. No, that's a good thing. Last thing that we want is that on the other side we have too many vacant properties because of this.
Yeah.
So thanks for sharing that. So hopefully that that will be taken in consideration. The third question that I have is about the overarching leasing principles. As a guide, it's supposed to help both parties of the lease agreement to arrive on the other side. In summary, what basic principles should landlords and lessees use during this period? Yeah,
so the code sets out two categories of principles, the first of which are called the overarching principles, and the second of which are referred to as leasing principles. So the overarching principles are more general in nature, and they primarily speak to the attitude that the National Cabinet is directing landlords and tenants to adopt when negotiating temporary lease variations in light of the Covid-19 pandemic. And the two key components of this attitude, if you will, are firstly, openness, transparency and good faith, which would include parties being upfront and honest regarding their financial position. And secondly, a spirit of cooperation rather than an overly adversarial approach. So effectively, the National Cabinet is encouraging landlords and tenants to work together as much as possible to arrive at mutually acceptable outcomes. The leasing principles are where the code gets more specific. They comprise a number of different requirements or guidelines that have to be followed when negotiating lease variations. This includes the matters already mentioned, such as proportionate rent reductions based on tenants' reduction in turnover, the prohibition on terminating leases for non-payment of rent, and the restriction on drawing on tenant security for unpaid rent. There are also a number of other matters, such as a requirement for landlords to pass on reductions of statutory charges to tenants, an obligation to grant tenants the opportunity to extend their leases for a length of time equivalent to the period of any rent reductions, and a prohibition on charging interest on waived or deferred rent. Now, on the whole, these leasing principles are clearly strongly weighted towards protecting tenants, and landlords would be within their rights to have some concern about them. And it's also worth noting that on the face of it, these principles do give rise to a number of questions and potential loopholes. And it's going to be interesting to see if and how these are dealt with in the WA regulations that adopt the code.
Yeah, okay, no, I understand that. And that actually leads us to the next question, which is what happens if the parties do not come to an agreement? You know, because you could have tenants now that are thinking, okay, great, there is this situation, it's has to go all our way, it has to be like we're in command now, and some landlords can simply not afford to do exactly what they're asking for. So when that happens, what avenues do they have?
Yeah, so one of the things that this new legislation passed by the WA State Parliament is going to do, once it's in force, is to provide a framework for parties to resolve disputes regarding the code. And what the legislation says is that when there is a dispute regarding the Act or the code that's adopted by the regulations, either landlords or tenants can apply to the State Administrative Tribunal for orders resolving the dispute. However, in relation to small commercial leases, so retail shop leases and leases where the tenant's operating a small business from the premises, and also certain other leases described in the bill, the parties will, in most cases, first need to request the Small Business Development Corporation to provide assistance to attempt to resolve the dispute or to undertake alternative dispute resolution before they can apply to SAT for orders resolving the dispute. So in many respects, the dispute resolution pathway that this new legislation puts in place is very similar to that which already exists for many disputes under the Retail Shops Act. That is, in the first instance, proceed to the Small Business Development Corporation and either undertake ADR or obtain a certificate that ADR is not appropriate. And then if the dispute isn't resolved through that Small Business Development Corporation process, make an application to SAT. Of course, we also recommend that if landlords or managing agents are having difficulties in resolving disputes regarding the new legislation or the code, they should also consider obtaining legal advice.
Yeah, okay, I understand that. And does the Code Administration Committee has any role within this?
Well, that's not clear yet. So the code states that it will be supported by these code administration committees, which it sets out will be made up of representatives from relevant industry bodies representing landlords, tenants and small business interests, and that there'll be an independent chair from the relevant state or territory government. However, the new legislation that's been introduced in WA doesn't actually address the issue of these code administration committees. So we don't yet know whether the committee will be established in WA, or if it is to be established, what its precise makeup and function will look like. So this is something that may be introduced through further legislation, but we'll just have to wait and see. So yeah, look, it's very much a watch this space at the moment in relation to these committees, along with a lot of other things.
Yes, it has been a lot of let's wait and see. There's been a lot of uncertainty since the middle of March. This code has been introduced on the 3rd of April, and you mentioned that you expect it will become law soon. But when do you think it will be legislated in WA?
Yeah, so yeah, as mentioned, this legislation that enacts part of the code, so certain of the things provided for in the code, has already passed state parliament, and it's either just received royal assent or it will receive royal assent very soon, at which time it will effectively come into operation. Yeah, once that happens, part of the code will already be law in WA, and that could be, in the next couple of days. In terms of when the regulations will be implemented adopting the balance of the code with or without amendments, there's been some indication from the government that this is around a month away, so we'll have to wait and see. But what's important to note is that the WA legislation backdates the operation of its requirements to 30 March 2020. And it would be a reasonable guess to think that the operation of the rest of the code, once that's brought in by these regulations, may also be backdated to 30 March 2020, but we'll again have to wait and see. It's also worth noting that the WA legislation sets out some transitional arrangements which will apply where during the period between 30 March 2020 and the date the legislation comes into effect, landlords have taken actions that are prohibited under the legislation. And in very broad terms, what these transitional arrangements provide is that where landlords have taken these prohibited actions during that transitional period, if those actions have been lawfully taken and are finalised, it's likely that they will stand and not be undone. But if the landlord has taken an action and it's incomplete or ongoing, then the landlord won't be able to complete it for the duration of this COVID-19 period, or the period in which the restrictions in the legislation apply. So as to how long these measures will remain in place, the legislation provisionally provides that they'll be effective until 29 September this year, but this is subject to change in accordance with the regulations that will be brought in.
All right. Okay. So that is a sort of an open expiry for that one. But certainly in these uncertain times, I think you've provided a little bit more certainty to us and to the audience here. So I thank you for that. No worries. I'll put, if anyone has further questions, I'm happy to facilitate an introduction and see if you are able to help them, both tenants or owners. And if they have a question for me, of course, I invite you to contact me privately. Thank you again, Simon. That was a very good conversation. Thank you. No worries. Thank you. Have a good day. Bye. Yeah. See ya.